Chair, thank you, Chair. No, I think the DG has clarified most of the points, which were sore point. But from where I'm sitting, there are two very important ones, which I think the NCOP must take very seriously and consider very seriously. Not to mean the others are less important, but these ones, I think the two I'm going to mention are the key to the complaints that we hear about, that this bill is unfair and unconstitutional. So the first one, I'll start from the last one, I'll make it first, is the last one that the DG has dealt with, this issue of signature requirement. I want to explain it very fully, and not to say the senior council has not done a good job, they have, but because members here might not be well acquainted with what is being said here. I want to explain exactly the background, where this comes from, and why are we here where we are. What the council is saying is that in 2006, sorry, in 1996, sorry, not 2006, when the Electoral Commissions Act was enacted, the Electoral Commissions Act is an act that founded the IEC. That means it's an act that brought the IEC into existence. In that act, in the regulations of that act rather, they are mentioning this issue of 1,000 signatures, what the council here called the deed of foundation, that a political party in its deed of foundation, that means in its founding document, must show that it has got support in the population, so that we don't go around registering one-man political parties, two-man political parties, or even 10 men, or even 100 men political parties, men here representing both male and female. So they said for that reason, they put these figures which you see on which you see on section 45(3), Roman figure 1, 2, and 3 of what the senior council has presented, that if the person, that political party, want to have a footprint nationally, then in their deed of foundation, they must bring 1,000 signatures. If on the other hand, they believe they are going to confine themselves to a province or a region, then they must bring 500. And if they are going to confine themselves to a metro or a district municipality or a metro, which means in all the elections, they will be confined there because their deed of foundation is saying so, then they must bring 300 signatures. That is what happened from 1996. Now, obviously, and for very obvious reasons, nothing could be said of independence, because there were no independence in the national and provincial legislatures. Independence were only found in local government. So nothing was said about independence. And we've been running like that from 1996. Now you fast forward 2022, we've been compelled by the court to include independence in both the province and national. Now suddenly an issue arises. If a founding document, founding provisions, a deed of foundation rather, for a political party is a certain number of signatures, what about an independent? Now independents do not have any deed of foundation. They are not required to register. No human being is required to register as an independent. Even in local government from 1996, we have not been doing so. They are not required to register. But what they are required to do is, you can't just wake up and find all independents on the ballot. There must be a qualifying criteria. In other words, there must be some numbers that are produced by independents to show really that they've got some bit of support. So in the act, Parliament was compelled to put something like that, because independents don't register, but to appear on the ballot box, ballot paper, as to avoid a million names on the ballot paper all contesting, there must be a qualifying criteria. And that criteria is in terms of money deposited, but also in terms of signatures. Now, there doesn't seem to be a lot of argument or criticism or discussion about the money. The issue here are signatures. People are then going back to compare with 1996, because in this bill, the amendment bill, Parliament then said for an independent to appear on the ballot, the signatures must be equal to 50% of the voters, of the votes rather, 50% of the votes that were required to win a seat in the previous election. That's what Parliament decided. After a long time, they said 50% is too high. It was taken down to 30% and eventually down to 20%. That means for an independent to appear on the ballot, they must acquire a number of signatures that are equivalent to the number of votes that were needed to win one seat in the previous elections. Now, this 20% is confusing people. Some take it as 20,000 votes, when actually it's 20%. Now, regarding what happened in the previous elections, 20% is equivalent to about 8,000 votes, not 20,000 as people are claiming. 20% an average seat, 20% of an average seat in the previous elections. Obviously, that's the election that took place in 2019, is 8,000 votes, which means all independents will have to acquire 8,000 signatures in order to appear on the ballot. Now, people are comparing this with the 1996 for a deed of foundation for a political party, which is a maximum of 1,000. And they are saying this is unequal. We, of course, do agree that this is unequal, and we think the NCOP must cure this inequality. That's why then there is this proposal that in the bill, we must now insert something that doesn't exist from the National Assembly. The NCOP must now insert that we now even go for new political parties, that any political party that is new, which wants to appear on the ballot, must also present the same number of signatures as is required from independents. That's number one, which must be in the bill. And number two, it must say for both the independent and the new political party, once they produce these signatures and win a seat in the National Assembly or provincial legislature, in the subsequent election, these signatures are not needed because they've already proven themselves that they do have support. This is to make sure that we equalize them with the present political parties, because even in the bill from the National Assembly, this signature requirement is not required from the political parties that are already in Parliament, for the reason that we believe they've got nothing to prove. They've already proved their worth, they've already proved their support. The fact that they are having a seat, even if it's one, shows that there is a certain number of South Africans who appreciate them and support them. And for that reason, nothing is required from them. So what we are asking you to do is to insert in the bill from the National Assembly, number one, that the number of signatures required for a new political party, and that is required for a new, an independent to appear on the ballot, for both to appear on the ballot, the signatures must be the same. That's number one, you must add. And number two, in that regard, that once they win a seat in the subsequent elections, they will no longer require any signatures from them. So that's basically the most important thing we're asking you to put in this bill, as opposed to what the National Assembly has done. The second one is this clamor for constituencies. This clamor for constituencies, which has pervaded the whole debate and actually destroyed the essence of the debate, that people say they want constituencies. If we dodge constituencies, then we are running away from responsibility. Now, there is a belief, Chairperson, out there that political parties presently participating in parliament, that affects me and you. Political parties in parliament want to be gatekeepers. They don't want to be voted out, and that's why they are uniting in keeping out independence in terms of constituencies. Because people who believe this story believe that once there are constituencies which are contested by independents, all political parties presently in parliament will be wiped out completely. Whether that is true or not, I'm not here to debate that. But the fact is that people are demanding constituencies. They believe constituencies will be a game changer to the present system which we are having, which is broadly represented by political parties. Now, Chairperson, we were not in principle fighting against the issue of constituencies. We never took a decision that there shall never be constituencies. We never did so. We just did not answer that because in this particular constitutional court ruling, that is not being provided for, is not an issue. In fact, Justice Madlanga, on paragraph 15 of judgment, I want you to go and read it, is also here, clearly said that issue is a purview of parliament. It's not part of the judgment that this type of electoral system is better than the other, and this one is good, and constituencies are very good, and all that. They said they are not venturing into that, and that they are leaving to parliament. Now, parliament being faced with this had to make a decision. Do we go into constituencies? We preferred not to answer that question, Chair, for the simple reason that there was no time, and I'll tell you why. If you look at option 2 of the Ministerial Advisory Committee, where they were saying we must choose between 2 options, option 2 was saying we must divide the country into 200 constituencies where independents and political parties will contest, and the other 200 seats will continue in the way they are doing. That means in the way of compensatory seats, which come directly from political parties. That is the option. Now, if we were to take that option of dividing the country into 200 constituencies, what it will mean was that Parliament was supposed to pause, start enacting a new legislation that will provide for a demarcation board. Because, Chairperson, I want you to understand me. The present board that demarcates municipalities, districts, and wards is a Municipal Demarcation Board Act. It's according to a Municipal Demarcation Board Act. It actually, the name actually so is municipal. It's not for national election. And the 200 constituencies that are mentioned in the Ministerial Advisory Committee, they do not exist. There are no 200 geographic areas in South Africa which you can point and say we can use these areas. It means a completely new demarcation altogether, which means then you must have an act that allows you. Some people were saying we need to amend the Municipal Demarcation Act in order to make it national. That will leave to lawyers whether that is legal or not. But even if that was to happen, that will need a lot of time, Chairperson. Even if we were to take the Municipal Demarcation Board Act and say we are transferring it or we're amending it into making national demarcations so that they've got the power to demarcate the country into 200 constituencies. Chairperson, there is no way under the sun that will happen within a period of 24 months. That's why people are even saying, even for the present bill, there is not enough time. So we realize that that is not the way to go. Some people in civil society believe we must go that way. We'll simply apply to the Constitutional Court to move the 2024 elections further away. And we believe the Constitutional Court will never agree to move elections. They've never agreed with local government, even for COVID. They said even COVID is not a good enough reason to move away elections from what the Constitution is prescribing. Remember, as to when the elections must take place, is prescribed in the Constitution. It cannot be changed by us willy-nilly or even by the IEC. We have got to go to the Constitutional Court, and they've already rejected that. Meaning what? There is no chance that they will ever agree to move to 2024 elections. They must take place. And if they must take place, Chairperson, there is no mechanism with which we can immediately put up a new act or amend the Municipal Demarcation Board Act, and then put up a demarcation board, and then from there to start dividing the country into constituencies. And I want people to be honest here, Chair. I want them to be honest, both politically and practically. We know what happens, even in Municipal Demarcation Board, that communities become restive. They don't just accept that, meaning they need a lot of time for consultation with community meetings. We all know what happened in Vuwani. Just when they were demarcating one part of the country into a municipality, we're not talking about the whole country or the 200 areas which is being proposed here. We're just talking about demarcating one area in Limpopo into a municipality in an area called Vuwani. 15 schools were burned down and all that, all hell broke loose. And so all I'm saying is not the reason why there mustn't be constituencies, but it's a reason why we need a lot of time in order to convince communities, for them not to burn the country, in order for them to accept what is coming for them, and they must understand it. We also know that there are political parties that formed in terms of demarcation of provinces. There is a political party in parliament that has been formed about the issue of Matatiele. Matatiele has been in Eastern Cape for a long time, but still there is still war that it must be remarcated into KZN. We also know the story of Mutse in Limpopo and Bushbuck Ridge in Mpumalanga. So what am I trying to tell you? That if we go that way, as is the clamor of civil society, that we must divide into constituencies, we must know that we need time. Now, in this bill, we realized that we didn't have time and we steered away from that. Unfortunately, that is a serious point of contention. So what must the NCOP do? The NCOP must find a process, as is being advised by senior counsel here, a process of satisfying the country, that we have not made any ruling against constituencies. We are just saying there's no time for this present bill, in time for 2024 elections, and satisfy them that after 2024, Parliament or South Africans still have got the right and power to start that debate on whether the country must get into constituencies or not. That is why senior counsel here is proposing that perhaps the NCOP must rule that a special committee of experts be approached and appointed in one way or the other to decide whether the constituency system is good for the country, and if it is, in what manner must it be done. Senior counsel here believes that Parliament is not the right structure to do so, because we are incumbents. We have already we already have positions on this issue and will be blindsided by how it will affect our political party. But an independent structure might sit and say, look, you South Africans, if you go to this issue of constituencies, this is what will happen. Remember, Chair, this issue was debated in CODESA. It's not something that's new, it was debated, and South Africa chose the present system. If we must change it, it will need another thorough debate, and there was just no chance here. But to satisfy those who believe political parties want to lock out constituencies because they want to save themselves, the NCOP must show them that that is not the case by putting something in the act to the extent that this matter will be looked into after 2024, whichever way you put it, but just to satisfy them that we have not discarded it, we simply did not have time for that. Those are the two issues, Chairperson, The others about the discarding of votes, allocations of seats and all that, I'm sure they are simple enough for the NCOP to be able to answer. I just thought I needed to guide you on these two main ones, which seems to be the pillars of the opposition to this bill. Thank you very much.